Hello, everyone. My name is Giancarlos Jamie-Guzman, and I'll be your host for today at the Lowellian. We're joined here today with Tom Carroll, who is from the Department of Labor and the Wage and Hour Division?
Correct.
Correct. All right.
Yes.
Would you mind introducing yourself and telling us about the work that you do here?
Sure. My name is Tom Carroll. I work for U.S. Department of Labor, Wage and Hour Division. For the Department of Labor, there are federal departments of labor, and then there's state. So I represent the federal branch for Department of Labor. I've been with the agency for 15 years. I was an investigator most of the years. And just recently I became the community outreach specialist to help the public and inform the public of their labor rights.
Zoning out a bit, could you tell us what exactly the Department of Labor is and why it's important?
Sure. U.S. Department of Labor is a big agency. There's a lot of sub-agencies under where Wage and Hour Division. We enforce the Fair Labor Standards Act, which is minimum wage, overtime, record keeping, and child labor. Under the Department of Labor, there's a bunch of other agencies. There's OSHA, which many people have heard of. That's for safety. There's EBSA, which is employee benefits, has to do with your pension. There's Employment and Training Administration, a bunch of different agencies, Women's Bureau. But it seems to me the most important is the Wage and Hour Division, because we actually help the public or employees to make sure that they're being paid properly and that their employers are complying with labor laws.
Zoning out even further than, like the Department of Labor and the subdivisions within it, I understand, that this program was developed in response to the Fair Labor Standards Act. Could you tell us more about the Fair Labor Standards Act?
Sure. That's our meat and potatoes of the laws that we enforce. We do other laws. We do government contracts. We do agricultural laws where we have temporary foreign workers that come over on H-2A, H-2B visas. But the most important one, well, not most important, the most common one we have is the Fair Labor Standards Act. And there's four parts of it. There's the minimum wage requirement, overtime requirement, child labor, and record keeping requirement. So the FLSA has been in existence for a very long time, since 1938. It had to do post-depression. And the main purpose where they started the overtime requirement was so that employers would have to pay time and a half to employees who worked more than 40. So they wanted to try to make more jobs available for more people instead of less people working more hours. They wanted more people working up to 40 hours. And if someone worked over 40, they had to pay time and a half the regular rate of pay.
That seems pretty fair.
Yeah.
Yeah. Going even further into the Fair Labor Standard Act, does it, get updated ever since it was introduced?
It does get updated. Obviously, minimum wage changes, and right now, federal minimum wage is $7.25. It's not even realistic, especially in our area in the Northeast. But hopefully, that will change. But our state minimum wage is $15. So the employer has to comply with both state and federal laws. So the minimum wage, they would comply with the state. The difference under certain laws, under the FLSA, is overtime. Massachusetts doesn't require overtime pay in the hospitality industry. However, the federal government does. So in that situation, if someone's working at a restaurant, they're entitled to overtime pay under federal law and not state law. So again, the employer has to comply with both state and federal regulations.
So you've already mentioned how both the federal and Massachusetts laws kind of differ between the minimum wage and overtime pay. Are there any other ways that they differ?
They're pretty similar. A few differences with child labor, but I would say overall they're pretty similar. The biggest difference is minimum wage and some of the overtime exemptions for employees under federal law or state law.
So could you tell us about some of the topics that your team specifically is breaking into?
Right now, it seems like overtime is the biggest issue that we have. There's having a big influx recently of migrants. We are seeing that there are a lot more violations. Employers sometimes think that they can pay undocumented workers less than minimum wage or not pay them overtime. So that's kind of a big issue right now. And the same as child labor, we've seen a lot of younger kids working when they shouldn't be, or they're working in hazardous occupations, which is not allowed. I can get into the child labor specifics if you'd like, but
Yeah, feel free to do
All right.
so if you
So
like to get in.
for child labor, it's similar in both state and federal law, but for 14 and 15-year-olds, you can only work up to 18 hours a week during a school week. You can only work 3 hours a day during a school day. You can't work during school hours, and it's from 7 a to 7 p, Monday through Friday. So you can really only work from 3 p.m. to 7 p.m. as someone that's 14 and 15-year-olds. On the weekends, they can work up to 8 hours, but it can't be more than 18 hours for the whole week. When school's not in session, they can work up to 40 hours. And then for the types of jobs, it's common sense. It can't be a hazardous occupation or an occupation that is dangerous. There's a specific list that we have for jobs that 14 and 15-year-olds can do. There's a great bulletin on our website, or you can just Google. It's the Child Labor Bulletin. And if you Google that, it's going to come right up, and it's going to give you the specific jobs that 14 and 15-year-olds can do. Once someone's 16 and 17, there's no restriction under federal law for the amount of hours that they work. I know under state law there is a limit of 48 hours in a week. So again, that's where state and federal laws differ, but under federal law there's no restriction on hours worked. So a 16 and 17-year-old can work any amount of hours under federal law, and again under state law a maximum of 48 hours. Again, it has to do with hazardous occupations. So it's common sense, but a lot of times you don't realize it. If it's someone's going to get hurt or lose a finger or really get seriously injured, it's a hazardous occupation. One that's often overlooked is a delivery driver. A delivery driver has to be 18 years old. Sometimes students do delivery for pizza places, etc., but they're not allowed to do it until they're 18 because they're not a seasoned driver and they're doing timed deliveries, so that's considered a hazardous occupation. But a lot of them have to do with construction, or there's a whole list. And the other thing for 16 and 17-year-olds is that they do have to get work permits from the state of Massachusetts in order to do that. But that, again, that's state law, so I'm not going to get too deep into that.
You seem to be very knowledgeable about that specific topic. Does your team regularly encounter this?
Yes, well, every case that we do, we look into child labor as well. It's a red flag for us. I mean, if some child is in danger, we want to make sure that that doesn't happen. So, and if we ever get a complaint or receive information that we believe that there's a minor working a job that's a hazardous occupation, we'll respond that day and stop the employee from working.
Yeah. You just mentioned right now how workers will file a complaint to you guys, but what would you say to those workers who might be hesitant to reach out to you or don't know how to go about it?
Yeah, so again, my position is community outreach. I go to a lot of advocacy groups throughout the state. I go to the consulates, many consulates from different countries, and I let them know that if they hear from anyone or any of their people in the community that aren't being paid properly or they're violating their labor laws, I get that information from them. And it does help if there's some undocumented workers. They're not going to call the government and say, hey, I'm not being paid properly. Obviously, they're nervous. We aren't immigration. We don't force the immigration laws. We just enforce the labor laws. So we make sure that everyone is being paid minimum wage and overtime. So that's a big help, because these individuals that go to the advocacy groups and speak to the workers there, they can question them and say, hey, is there any issues you're having with your employer? And they'll let them know that they have a contact in the Department of Labor, that they'll reach out to us with the information. And then once we gain their trust, we speak to them and they give us the information. It's a lot better when we have specific information of an employer before we go in. Sometimes we go into employers and we don't know much what's going on there, but it depends on, we have initiatives that depend on where we find a lot of violations. Obviously, it's restaurants, it's construction companies, it's hospitality, like hotels, etc. Temp agencies is a big one. So we do a lot of initiatives without a complaint as well.
What are some of the most common ways that workers face unfair work environments that somebody might not be aware of?
Usually, if someone is undocumented, and the employer most of the time knows that. They will try to get away with paying them in cash and saying, oh, well, since we're paying you in cash, we're going to pay you less than minimum wage. So instead of paying you $15, maybe we'll give you $12 an hour in cash, and then we won't pay you overtime. If they may work 50 hours a week, get $12 an hour cash. So that it's a violation of tax laws as well. But again, we're the Department of Labor, we only enforce the labor laws. But that individual down the line, if they start being treated terribly or, demeaned at work, they sometimes will reach out to the advocacy groups who will inform us of this individual who's not being paid properly. So a lot of employers too will try to make workers classified as independent contractors as opposed to an employee, because an independent contractor is exempt from overtime. When they're not covered under the Fair Labor Standards Act, they're not considered an employee. We have to determine what's the employee-employer relationship. And once we have a case and we speak to the individual and say, oh, who tells you what to do, who pays you, what's your schedule, who tells you you can leave early from work, there's different, I'm trying to think how many questions there are, but once we determine that that person is an employee, by definition, then that person is covered under the Fair Labor Standards Act, which is the minimum wage and overtime. A lot of employers try to make an individual or claim them as a independent contractor, because then if they're not an employee, they don't have to pay workman's compensation, they don't have to pay unemployment insurance, so it saves the employer, but the employee gets hurt in this scenario.
I see. So what you just stated, I feel like reaffirms this statement that I saw online, that like the biggest source of theft isn't from like identity theft or property theft, is instead wage theft. So you've mentioned how the different ways that this can happen, but how does your department deal with that directly?
It's just usually there'll be a violation of the Fair Labor Standards Act. So even you see a lot of employers, like right now, the minimum wage has gone up a lot over the last few years. Still, $15 isn't great, but it's at least $15 an hour. But employers try to save any way they can, and then they're finding out that their costs are a lot more, especially like in the restaurant industry or these smaller companies. So sometimes they try to shave off hours as well. We see that if someone clocks in at a certain time and they clock out, they make the employee work sometimes after they're clocked out, so that they're saving a little money by not paying the employee all the hours that they're worked. Hours worked is a big issue for us, because if they're allowed to work or they do work, it's called suffer or permit, they have to be paid for those hours. A lot of employees will come in, if they start at 8 o'clock, they may come in at 7:30 and they may read their emails or something regarding their work, and then they start at 8. But they're required to be paid from 7:30 when they start work, because they are working, they're suffering work. An employer can say, well, I didn't let you work from 7:30 to 8, so they can discipline them and say, well, next time you do that, make sure you get permission. But if they've already worked, they have to be paid for that half hour. Same thing with lunch breaks. A lot of employers will automatically deduct 30 minutes a day for the lunch break, and some employees work through their lunch break. So it's only that 30 minutes, but that's 2.5 hours a week. And if you have 100 employees, that's a lot of money that the employer is saving. So we try to make sure that there are records if there is a formal lunch break, because they don't have to be paid if they're relieved from their duty of 20 minutes or longer. And that's what the employer wants, to make sure that they're not being paid when they're not working.
Is there like something that folks at home may not know about labor laws that you feel is important for, regular people to know?
Yeah, a lot of people don't realize that there's agencies out there to help them. They get frustrated and they try to speak to the employer, and then it creates bad blood. It sounds like they're complaining, but it is an issue where, they need to have all their wages for all hours worked. So to let them know that there are agencies out there that can assist. When someone calls us and they file a complaint, that's confidential. We don't tell the employer, this employee called. When we go to a company, usually their first response is, who called on me? And we say, oh, we don't have that information, because we work a case that is an initiative case that we just work because there's usually problems in that industry, or it's a random case, or it's a complaint case, but we don't give out information to the employer as to why we're there. We're saying we're there to make sure that you're in compliance with all the labor laws. And we're not out there being a bad guy. We just want to make sure that you're in compliance. We want to educate you if you're not in compliance. So yeah, employers do get nervous when we walk in, but we try to make it, as easy as a investigation or an audit, as we can. We like to work with the employer, and we like it when they work with us as well.
Yeah, I appreciate that. You've mentioned a few times throughout the interview how like people can come check out your website or call to make a complaint. Can you tell us like the different ways that people can reach out to your department or other departments?
Sure. We have an 800 number, which usually a lot of people go, oh, an 800 number, I'm never going to get through. But we have a number, it's 866, then 4 US wage, 866 4 US wage. And when you reach that line, you have to enter your zip code. It asks, please enter your zip code, and you get sent to the nearest wage and hour office closest to you. So for Lowell, it would be in Boston. We have an office in Taunton, and we have one in Springfield as well. But you'd be referred to Boston. And we have duty officers who answer the phones. Every investigator is on a wheel, and each day that there's a live person at that number. So if you call between 8 and 4:30, you're going to get a live person, and you can ask any question you want. And sometimes we get questions that aren't even related to our agency, but at least we'll know where to refer you to. If it's unemployment sometimes or workman's comp, that's not us, but we'll say, oh, we have a number for the state. This is who you can reach out to. If someone doesn't answer because they're on the other line, you leave a message and you get a call within 24 hours. So for a government agency, we're excellent on returning calls or speaking with the public. And then we also have a good website. It's just DOL, DOLWHD, and it has all the laws in there, but it's just sometimes when you're searching through all those laws, it does get overwhelming. So it's easier to just call the number, ask your specific question, and we'll assist with that. And I always say, if you have a question, an employer has a question on child labor issues, definitely reach out to us, because you don't want to inadvertently hire a minor in violation. It's not just from us. We may find the employer and say, hey, you violated child labor laws. You're being a civil money penalty or a fine, $5,000 or whatever. But that's nothing, because if that child gets seriously injured at work and you hired them unlawfully, that family is going to sue you and you can lose your business. So for us to point out that information or that violation to you can save your business, because we want to prevent the child from getting injured and you, an employer, losing their business.
Oh, well, thank you for that information.
Yeah.
And then finally, wrapping up, is there anything else that you'd like folks at home to know about the Department of Labor?
Yeah, recently we've done a lot with retaliation. A lot of people are afraid to speak up at work because they think they're going to be retaliated against. So recently we have really good attorneys for our agency. If there are egregious violations or the employees are being treated horribly, we can assist with a retaliation. So if an individual calls us and says, hey, I'm working at this company, I'm undocumented, but because of that reason I'm being treated badly, I'm being paid less than other individuals, I'm not being paid overtime, and they use my immigration status against me and to try to create a fear. And we call that retaliation, because they're retaliating against the employer for standing up for their labor rights. So for retaliation, if we have enough or we get a good interview from the employee, then the employer can get charged with punitive damages for that employee. Also the employee, if they're undocumented, if it's a case where there's labor exploitation or even possible labor trafficking, that employee, since they speak to us with our investigation, they can get status out of that investigation. We do a certification if that individual assisted with our investigation, and with that certification they can apply for a U or V visa with USCIS or with immigration. So I'm responsible for notifying employees of that additional right. The investigators don't, because we don't want it to look like a promise, like you tell us information and we'll get you a U visa. That's not how it goes. But if they have information that we find is very bad against the employer, I notify them as a third person and tell them about their additional rights for certification under U.S. Department of Labor that they can use to apply for immigration status. So that's something new over the last 5 years or so, and we've seen it a lot more often because of the big increase in undocumented workers right now in the country. A lot of employers are trying to take advantage of that situation.
Wow. Well, what you're doing sounds incredibly helpful and should, be beneficial to anybody who's watching this,
Yeah.
somebody specific.
So if anyone has issues, and you can reach out to an advocacy group in your community, or you can reach out to your consulate. And I reach out to all these institutions, and they can forward the information to me. Or if you do want to call our number, you can call that 866 number and leave the information. And again, it's confidential. We're not going to call the employer and state that that your employee called and we're coming to your business to audit your company. So just be aware that even if you don't have status through immigration, you still have your rights under labor laws in the United States.
All right. Well, thank you so much for taking your time out of your day to talk with us. Once again, my name is Giancarlos Jamie-Guzman. This has been Tom Carroll, and you've been watching LTC's The Lowellian. Thank you.
Thank you.